Good afternoon, everyone. Thank you for joining me for Seacrest Wardle's Michigan PIP Monthly May 2018 version. My name is Javon David, and I am a partner at Seacrest Wardle's Troy location. The purpose of the Michigan PIP Monthly is to provide you with a podcast that you can listen to on the go or just kind of in the background while you're doing work in your office to help you stay on top of Michigan law and any current issues that are percolating in litigation that will affect claims handling or any cases that you have that are currently in litigation. Now, each month we try to feature different topics. We also take requests from our listeners for different topics that they want discussed for the upcoming months. For May 2018, this is one of those times where one of our listeners have requested that we discuss the Barnes versus Farmers Insurance case. And not only discuss the case, but kind of talk about the intricacies that are involved in a Barnes kind of matter and any case law that has recently come down. So I'll go through all of that today. This might be a refresher course for some of you, but it never hurts to be reminded as to the specific facts of Barnes to make sure that you're applying them correctly in your claim handling and in litigation generally. Now, after we discuss Barnes today, we'll go through the Court of Appeals update. Of course, the most significant case that has come down since the last podcast is the Shaw versus State Farm matter. That is the case that is, again, published and interprets Covenant versus State Farm and deals with a lot of the issues that we've been making in oral argument and in our motions for summary disposition based upon Covenant. So I'll go through what Shaw versus State Farm held, how to address Shaw versus State Farm, and what to do about Covenant motions going forward and any pending Covenant motions that you may have. Now, for those of you who handle a lot of PIP cases, coverage issues come up and are addressed primarily pre-suit, but they do often come up in litigation as well. In any event, coverage for vehicles is governed by 3101 and requires an individual to purchase insurance for a motor vehicle. In addition, MCL 500 3.113 subsection B provides in pertinent part that a person is not entitled to be paid personal injury protection insurance benefits for accidental bodily injury if at the time of the accident any of the following existed, and among the subparts includes the following provision. The person was the owner or registrant of a motor vehicle or motorcycle involved in the accident with respect to which the security required by Section 3101 was not in effect. Now, just briefly, in Barnes versus Farmers Insurance Exchange, the full citation is 308 Mich. App 1. It's a 2014 case. In Barnes, plaintiff was injured when driving a car she owned jointly with her mother. Neither plaintiff nor her mother had a no-fault insurance policy in effect. However, there was a policy on the vehicle at the time of the accident in the name of a friend of the plaintiff's mother who regularly drove and garaged the vehicle. The trial court held that the friend's policy was insufficient to meet the requirements of MCL 500.3113B, and the Court of Appeals affirmed that ruling, clarifying that while the Iqbal case held that each and every owner need not obtain insurance, it did not allow for owners to avoid the consequences of 3113 if no owner obtained the required insurance. So essentially what the court did is stated that the vehicle that was listed on the friend's policy was insufficient to allow the plaintiff to recover first-party benefits because the plaintiff jointly owned the vehicle with the mother. And since the plaintiff was the owner of the vehicle along with the mother, they were required under the No Fault Act to insure that vehicle in their name. Now, people often ask, why is this the case? What is the overarching policy reason for this issue? And it's simple. You have to have an ownership interest in something to ensure that you are going to be concerned with the risk of something happening, just with insurance generally. You know, if you have house insurance, the risk is on you. It's your house. You own the home. So you're the person that's going to be applying for the insurance. You're the person that's going to have the potential losses to you if something were to happen to your house. It goes with anything that you insure. This is the same kind of public policy reasoning when we're requiring owners of vehicles to insure the vehicles. They have to have the ownership interest, and it ensures that they their interest will be aligned with that of the insurance company. Now, Barnes focused a lot on this Iqbal case that is mentioned in essentially every kind of Barnes analysis. And Iqbal is an interesting case. It came out before Barnes. It came out in 2008, and it involved multiple parties. So let's discuss the interplay with Iqbal and Barnes. In Iqbal versus Bristol West Insurance Company, the plaintiff was injured in an accident while driving his brother's vehicle. The plaintiff had a set of keys to the vehicle and permission to drive it when his brother did not need it. He used the vehicle several times a week. The brother insured the vehicle through Auto Club, and the plaintiff, who lived with her sister, was covered under the household no-fault insurance policy issued by Bristol West. So the plaintiff was covered as a resident relative, essentially, of the Bristol West Insurance Company policy. The ACP was also a party to the action, and Auto Club and the MACP argued that Bristol was responsible for paying PIP benefits under the priority statute. Bristol Insurance argued that plaintiff was the constructive owner of the vehicle pursuant to MCL 3101 because he had the use of the vehicle for more than 30 days. Because plaintiff did not maintain insurance on the vehicle, Bristol claimed that he was precluded from receiving PIP benefits under MCL 500-3113. The Court of Appeals disagreed. It held that even assuming that plaintiff was an owner, 3113B links the security or insurance requirement to the vehicle only and not the person. Because the vehicle was covered by the brother's no-fault insurance through Auto Club, plaintiff was not precluded from recovering PIP benefits from Bristol. The holding in Iqbal would not preclude a no-fault insurer from rescinding a policy if the person seeking to collect the no-fault benefits procured the policy through any kind of concealment. So always remember that, of course, you still have the concealment and misrepresentation issue, especially in a fact pattern like that where the person didn't disclose that another individual had the vehicle for more than 30 days at a time and was essentially the constructive owner of the vehicle. Those arguments are still going to be available to you. But again, while Iqbal held that each and every owner need not obtain insurance, it did not allow for owners to avoid the consequences of 3113. Now, that's just a general overview of Barnes versus Farmers and kind of the cases and the arguments that you see with regard to any kind of Barnes argument. And essentially, an individual needs to have an ownership interest in the vehicle and also insure that vehicle. Otherwise, they could be precluded from collecting first-party benefits. There's not too many cases that have come down analyzing Barnes, but there was a recent case in 2018 called Alani versus Geico, and that is an unpublished case, but it still goes through Barnes pretty nicely and discusses commercial use versus personal use for purposes of 3113. And in that case, plaintiff was injured while operating a Chrysler Town and Country as part of a taxi service. The Chrysler was registered and titled solely to plaintiff doing business as Superstar Transportation. However, the vehicle was insured to plaintiff's brother, Abdul Alani, doing business as Star One, through a commercial policy with Sentinel Insurance. In the trial court, Sentinel filed a motion for summary disposition and argued that plaintiff's failure to personally maintain insurance coverage for the vehicle that was registered and titled solely in his name disqualified him from PIP benefits under MCL 500.3113B, which is the provision that Barnes stems from. The trial court found Barnes to be inapplicable as it contemplated personal use of a motor vehicle as opposed to vehicles used for business purposes under a different part of the statute, which is 3114 subsection 2. I'll go through that too. So 31142 states that a person suffering accidental bodily injury while an operator or passenger of a motor vehicle operated in the business of transporting passengers shall receive the personal protection insurance benefits to which the person is entitled from the insurer of the motor vehicle. The Court of Appeals rejected this distinction, overturning the trial court, and found that 3114 deals only with the priority of insurers after the individual's entitlement to benefits has been established. So first you have to establish entitlement to benefits generally, and then you go to see who is going to be on the hook for those benefits. The court referenced the explicit language of the statute that limits recovery of PIP benefits to those benefits to which the person is entitled. Accordingly, the court found that the trial court should have first addressed whether the plaintiff was entitled to PIP benefits under 3113 before even analyzing the priority statute of 3114. Accordingly, as the plaintiff was the sole owner of the Chrysler he was operating at the time of the accident, and he did not personally maintain a policy of insurance for the Chrysler, the court found that he was ineligible for PIP benefits. So this is a good case to reference if you're dealing with commercial policies and trying to assess any kind of coverage dispute there. First, look to see whether the plaintiff's even entitled to any benefits before you do any kind of further analysis. That case can also be helpful to just a general and more recent analysis of Barnes and what the court meant when issuing the Barnes opinion. If you have any questions on Barnes, feel free to contact me. I can provide you with more written materials or answer any questions that you may have that are case specific. Now, for the moment you've all been waiting for, a discussion of the Shaw versus State Farm case, which was issued on May 8th, 2018, and is a pretty substantial decision that has come down since the covenant was issued about a year ago. Now, the Michigan Court of Appeals tackled the hotly contested issue of the enforceability of anti-assignment clauses in insurance policies in the recent published decision of Shaw versus State Farm Insurance Company. Just by way of background, after covenant was released and issued, we still had a leg to stand on to preclude these provider claims. The providers were essentially relying on a footnote in covenant that stated that their ruling does not affect any potential assignment of claims or assignment of rights to collect on behalf of the injured claimant. In response, insurers turned to their own policies of insurance and stated that we have an anti-assignment provision that generally in these policies it says that you cannot assign your rights under the subject policy of insurance. After motions for summary disposition were filed, arguments would often go back and forth on these two issues, and judges in the trial court were ruling in very different ways as to whether or not an anti-assignment provision in a policy is enforceable. Some judges were just adjourning motions until the eve of trial. It just was a pretty big mess in the trial court and in the district court actions as well with regard to the enforceability of anti-assignment provisions and policies of insurance. Fortunately, the Shaw case does clarify for that, as the ultimate holding in the case was that anti-assignment clauses are unenforceable with respect to medical providers once the services have been rendered. Importantly, though, the court did hold that the one-year back rule would apply from the date of the execution of the assignment, and any amended pleading to add a claim based on the assignment would not relate back to the date of filing of the original complaint. So in the Shaw case, just by way of background, Shaw and 3 other medical providers filed suit seeking to recover payment for services provided to the claimant, George Hensley, a State Farm insured, as a result of alleged injuries he sustained in a motor vehicle accident. Following the release of Covenant versus State Farm, the defendant moved for summary disposition and argued that provider plaintiffs had failed to state a claim upon which relief could be granted. In the interim, the provider plaintiffs obtained an assignment of rights from Mr. Hensley dated after the filing of plaintiff's complaint, and subsequently filed a motion for leave to amend the complaint to reflect that the suit was being pursued through the assignment of rights. In its reply, State Farm set forth a number of arguments. Number 1, they argued that the anti-assignment clause in the policy rendered any assignment of rights from Hensley void. Number 2, the one-year back rule of 3145 barred the assigned claims or a portion thereof, even if the assignments were valid. And number 3, the relation back doctrine does not apply because the assignment did not exist on the date of plaintiffs originally filed their complaint. In granting State Farm's motion for summary disposition, the trial court relied on the insurance policy language precluding any assignment of rights without the consent of the insurer. Specifically, the trial court reasoned that as the insurer did not approve any such assignment, the provider plaintiffs did not acquire any rights by virtue of the assignment, and therefore State Farm was entitled to summary disposition. On appeal, the Michigan Court of Appeals reversed the trial court and remanded the case back to the lower court for further consideration. In the opinion, the Court of Appeals affirms the retroactivity of covenant. However, the remainder of the opinion focuses on the enforceability of a contract provision prohibiting an assignment, a provision that is found in one form or another in many of the insurance policies that we see on every case. So in holding that the anti-assignment provisions are unenforceable following a loss that has been incurred, the Court of Appeals relied on a case from 1880, over 100 years old, and that's the case of Williams versus Carrington. In that case, the Michigan Supreme Court refused to enforce an anti-assignment clause, explaining the assignment having been made after the loss did not require consent of the company. The provision of the policy forfeiting it for an assignment without the company's consent is invalid, so far as it applies to the transfer of an accrued cause of action. It is the absolute right of every person secured in the state by statute to assign such claims, and such a right cannot be prevented. It cannot concern the debtor, and it is against public policy to have any kind of anti-assignment clause in the insurance policy. Now, although the case is from 1880, it does provide the policy arguments for precluding any kind of anti-assignment provisions, and it is binding as it is a Michigan Supreme Court case. So the Court of Appeals reasoned that in this case, the Shaw versus State Farm case, Mr. Hensley held an accrued claim against his insurer for payment of health care services that had already been provided by plaintiffs before Hensley executed the assignment. Ultimately, the Court of Appeals concluded that enforcement of the anti-assignment clause in the instant case is unenforceable to prohibit the assignment that occurred here, an assignment after the loss occurred for an accrued claim to the payment, because such a prohibition of assignment violates Michigan public policy that is part of our common law set forth by the Supreme Court. So what the Court of Appeals did here is they looked to the Michigan Supreme Court case and said it's binding precedent, and also it violates public policy to have these kinds of clause. Now, I guess the silver lining that comes out of Shaw is that it does provide some sort of argument for precluding a portion of the claims based upon the one-year back defense. The Court of Appeals held that by seeking to file an amended complaint based on an assignment, plaintiffs were actually seeking to file a supplemental pleading, which could not relate back to the date of the original pleading. So in the Shaw case, the assignment was obtained after the filing of the original complaint, and as such, the plaintiff could not obtain any greater rights from Mr. Hensley on the date of the assignments than Hensley himself possessed on that date. So the Court of Appeals concluded that through the assignment, plaintiffs did not obtain the right to pursue no-fault benefits for any portion of the loss occurred more than 1 year prior to the execution of the assignment. Ultimately, the Shaw opinion holds that an insured is permitted to assign his or her rights to a medical provider for recovery of payment for medical service rendered, regardless of any anti-assignment provision in the underlying policy of insurance. But again, it's important to keep an eye on the date of the assignment, as the Court of Appeals determined that it is that date which is controlling for purposes of 3145 and the one-year back rule. Again, the Shaw case is a published decision, which means that it is binding on the lower courts. So if you bring an argument for under covenant, and say that while our insurance policy provides this anti-assignment clause, you're going to be faced with a very strong response by the plaintiff saying Shaw came down and wiped out this argument, and it's binding authority, meaning the trial court has to follow this case. So what do we do now? Covenant came down a year ago. Now we have the Shaw case that discusses the anti-assignability clauses in the policies that we relied upon to refute the provider's claims that they still have a right as long as they have an assignment to pursue these claims. There are a few options, but of course this is going to be up to the discretion of the carrier that you work for, and I'm sure there is some sort of internal discussion already happening given these kinds of things, and your counsel should probably be contacting you with any covenant motions that you have that are pending. But there are a few options. So you can move forward with the motion and argue that the policy language at issue in your case differs from State Farm's policy language in the Shaw case. However, you need to address that with caution, because the court may find that the policy language is similar enough to invoke application of Shaw. What's more important is that the court might also look to the overarching ruling made by the Court of Appeals in finding that an assignment of rights in provider suits is valid, and that the anti-assignment provision in policies is prohibited as violating public policy. You have to be careful if you do move forward under these circumstances, because depending on who the judge or the court or the plaintiff attorney is, sanctions may be at risk. And of course, these would be sanctions that the court could issue and take upon themselves for the filing of a motion that is contrary to published case law. So it would essentially be a frivolous motion sanction, and certainly not a sanction for like no-fault attorney fees or penalty interest or anything like that. So you can also adjourn the motion for summary disposition and monitor the Shaw case for appeal purposes. We fully expect that State Farm will be appealing the Shaw decision to the Michigan Supreme Court. However, it's unlikely that the Supreme Court will take the case by the end or conclusion of your provider suit, depending on how new your case is or how much time you have until the trial date. You can also enter into a stipulated order denying the motion for summary disposition without prejudice, but preserving your right to an appeal based upon the potential for the Shaw case being overturned. Of course, these options are in your discretion, and your counsel should be talking with you before making any kind of move on this case, because there are serious consequences to what you do next. If you just dismiss your motion, are you waiving your right to appeal the issue if Shaw is overturned? Arguably, yes. If you go forward with the motion, are you at risk for sanctions for filing the motion and pursuing it? It depends. It depends on your plaintiff attorney, and it depends on your judge. But these are all things to consider in a conversation as to who the attorney is, who the judge is, how strong your arguments are going to be, and what you actually want to do on the case is something that should be had with your counsel. I briefly touched on this, but the difference between sanctions for like the filing of the motion and all of that is going to be different than the provider trying to seek sanctions for interest and attorney fees. There's case law that we've written on and discussed in prior podcasts and affirmed by the trial courts, indicating that these providers can arguably not collect on penalty interest and attorney fees, as statutory interest and attorney fees were typically considered future benefits and could not be assigned. So you cannot assign something in the future, therefore you cannot assign attorney fees and interest because they have not been accrued. And that is consistent with the case law that was cited in Shaw, the 1880 case, and all the case law that's come down since analyzing any potential interest and attorney fees. So I hope that clarifies what Shaw did and what to do going forward, some options to discuss with your counsel. If you have any questions about the topics that were covered in today's Michigan PIP Monthly, feel free to contact me. Again, my name is Javon David. I'm a partner at Seacrest Wardle's Troy office. My contact information is located on slide 8. Also, if you have any suggestions or any topics that you want to be discussed during a podcast, feel free to email me as well. Like I said, the Barnes discussion was prompted by a couple questions we had from adjusters, and then ultimately a request to have Barnes discussed just as kind of a refresher course for people that are listening. Again, thank you for listening to Seacrest Wardle's Michigan PIP Monthly. I look forward to having you join me next month as well.